Welcome to the series of online mini courses organized by CTEC Hong Kong. This really focuses on practice in the COVID-19 environment. My name is Koh Swee Yen. I'm a partner in Commercial and Corporate Disputes and International Arbitration practice of WongPartnership Singapore. Today, I'm going to speak about remote hearing. Is it business as usual? What used to be exceptional in the past, namely that of remote hearing, is now the norm in today's environment. I think one thing which is the same is that preparation is essential. The manner in which counsel prepares for a virtual hearing, a remote hearing, is the same as the manner in which a counsel should prepare for an in-person hearing. In fact, one would imagine that one needs to be even more familiar with the cross-referencing and with all the various documents that are on record so as to ensure that the virtual hearing, which is not taking place in person, moves efficiently. Preparation is key, and preparation does not just extend to the knowledge of the case, but also the preparation of the banders ahead of the hearing. I think, particularly in a remote hearing, it is very important to ensure that the tribunal members, the opposing counsel, as well as the witnesses who are dialing in from all different locations have access to the same banders. Thus, ahead of a remote hearing, it is very important to ensure that all the banders are prepared in advance of the hearing. One may consider whether to make use of soft copy bundle of documents or hard copy bundle of documents. Personally, I found that using physical hard copy bundle of documents is actually more efficient and effective unless one is able to be very familiar and adapt at the screen sharing function. As we all know, with the conduct of a remote hearing, there is the availability of a screen sharing function. But to enable the screen sharing function to work, it is essential that the counsel is assisted by the second chair or the third chair who is very familiar with the documents and who is able to pull out the documents almost instantly with the snap of a finger so as to ensure that the remote hearing is not unnecessarily disrupted. And because this does take a lot of time to get familiar and used to, my personal preference is actually for all parties, tribunal and witnesses to have the same physical hard copy of documents. The second point that I would raise in relation to the preparation for a remote hearing is to ensure that there is a trial run that is conducted ahead of the remote hearing. The trial run should involve the tribunal, the opposing counsel, as well as the witnesses and the moderator of the remote hearing. Typically, if you have a remote hearing and you make use of one of those facilities, for instance, those offered by Maxwell Chambers will provide a moderator for the hearing. The trial run should take place several days ahead of the remote hearing, and during the trial run, the moderator can be given instructions to set up the necessary breakout rooms for the parties. Breakout rooms can be set up for the tribunal, for the parties' counsel and their clients, as well as for the witnesses if necessary. The importance of setting up the breakout room is to ensure that parties' counsel and their clients are able to communicate with each other in the course of the remote hearing, bearing in mind that they are no longer together in person in a physical location. And more critically, it also enables the tribunal members to have a breakout room where they can have deliberations amongst themselves. Further, this trial run would also enable parties to be familiar with the use of the facilities that's available remotely. For instance, the private chat function that is available for the counsel to chat privately with perhaps its clients. Related to that, as part of the trial run, it is also critical to actually have the transcription service provider involved in the trial run. Personally, based on the recent experience that myself and my team had in a remote hearing, we found that real-time transcription services are in fact essential. Real-time transcription services would ensure that all parties, the tribunal, counsel, as well as witnesses, have a real-time recording of the exchanges that is taking place. And this is particularly important, especially for a remote hearing, because at times there may be difficulty with the audio and the sound recording, and one may need to look back at the transcripts to fully appreciate what has just happened. And this real-time transcription services also enables parties to keep on track with the development of the remote hearing. In fact, the real-time transcription services also provide an additional advantage because within the real-time transcription services, there is also the availability of a private chat where the counsel can chat with the clients and through that system, take instructions from the client. And this is very important for remote hearing where they are not physically next to each other in the same room. One thing that should also be borne in mind when there's the use of real-life transcription services is that counsel should ensure that there are at least 2 monitor screens that are available for the transcription services. So to enable that the hearing actually proceeds smoothly, one screen should be used for the hearing, for the remote hearing, and another screen used for the transcription services. This is very important because it is very difficult to follow the transcription as well as the remote hearing if all you have is one screen. If you are using the screen sharing function, it may even be necessary to have a 3rd screen. One other 3rd point that I would deal with in terms of the logistics and the preparation ahead of the remote hearing really relates to the importance of communications prior to the remote hearing. So between counsels have to agree on various administrative matters ranging from who are the parties that would have access to the real-time transcription services, when would the witnesses be entitled to access the real-time transcription services, and particularly what is the control environment in which the witnesses should undergo cross-examination. In a true remote hearing, the witness would be alone by himself or herself in a room. While counsel can agree that there will be no other third party present, while counsel can agree as to what are the documents that are made available before the witness, one thing which counsel can agree on but perhaps have very little control over is whether the witness in the course of the examination may receive cues through the monitor screen, through the computer that the witness is looking at. This, unfortunately, is one of those things which I think is almost impossible to control in a remote hearing. In an in-person hearing, one can ensure that the witness only has access to a particular computer and that the access is restricted. But when we talk about remote hearing, it is almost impossible to control that. So ultimately, I do think that there are some factors in a remote hearing which may not be controlled. And one of these things would be the environment in which the witness is cross-examined. But this is something that we would have to try our best to mitigate the situation. So for instance, counsel may require the witness to perhaps sign a declaration prior to the remote hearing to confirm that the only access that the witness has, or that the only sort of connection that the witness would have during the course of the cross-examination would be to the remote hearing and nothing further. I then want to speak about perhaps some of the key differences between an in-person hearing and hearing in person from the perspective of counsel's interaction with the tribunal and from the perspective of counsel's cross-examination of a respondent's witness. So I think the best way to present this would be to do a simulation with the tribunal. So what I intend to do is I have my colleague, Mr. Zhuang Wenxiong, who will assist us with this simulation. He will first play the role of a tribunal, and I will play the role of a claimant's counsel, and I will try to simulate the remote hearing and show how to ensure that the advocacy is effective in the presentation of an oral opening to the tribunal.
Ms. Koh, this is Mr. Zhuang. I am the tribunal for case X of Y. Could you please tell me a bit about your case and what it's about?
Yes, sir. My name is Koh Swee Yen, and I act for the claimant in this arbitration. Sir, the claimant's claim against the respondent is for damages for breach of various representations and warranties in a contract for the sale and purchase of shares in a company known as Central Medical, which owns and operates various hospitals in China. Sir, if I may trouble you to turn to the contract at hand, this can be found in Agreed Bundle of Documents, Volume 1 at page 150. You can see from the execution page that the contract was executed by the parties on 1st October 2018. Of particular relevance are the clauses relating to the representations and warranties made by the respondent to the claimant. Sir, if you can now turn to page 170 of the Agreed Bundle.
Yes, Ms. Koh, I'm at page 170.
Yes. Clause 4 of the contract provides that the respondent represents and warrants that the representations and warranties given in Schedule 5 of the contract are true and correct at the time of the contract and at the time of the completion. If Sir now turns to page 300 of the same Agreed Bundle of Documents, Volume 1, you can find Schedule 5 of the contract.
Yes, Ms. Koh, I'm at Schedule 5 of the contract.
At paragraph 1 of Schedule 5, it states that the respondent warrants that the hospital in Beijing will be constructed and completed in accordance with the project schedule. As matters turn out, sir, this warranty is untrue. The hospital in Beijing was not constructed and completed in accordance with the project schedule. In fact, as of today, as we speak, the hospital is still not fully operational. This is a simulation which we have done with the tribunal. And there's a few points that I want to highlight from this simulation. One is that it is very important to maintain eye contact with the tribunal. To ensure that there is a maintenance of the eye contact with the tribunal, it is very important to ensure that the camera is placed at the eye level of the counsel, so that at the same time while you are looking at the screen and observing the tribunal's facial expression, you are also speaking directly into the camera and are maintaining eye contact with the tribunal. That's the first point. The second point is that it is important to continue to watch the tribunal and to watch the body language of the tribunal. So for instance, in the simulation, you would see that the tribunal, Mr. Zhuang, has actually responded and stated that he is actually following my cues and my references to the various pages in the agreed bundle of documents. So I must ensure that the tribunal is still following me when I'm bringing the tribunal through the various documents on record. And the third point is that I think it is important to speak at a much slower pace so as to ensure that there is clarity in the delivery of the written submissions. I will then next show a simulation with the claim with the respondent's witness. So I will be playing the role of the claimant's counsel, and I'll be cross-examining the respondent's witness. And in this instance here, Mr. Zhuang will play the role of the respondent's witness. Good morning, Mr. Zhuang.
Morning, Ms. Koh.
Mr. Zhuang, what is your role in Central Medical?
Oh, Ms. Koh, you see, I'm the CEO of China Medical, so I'm like the Steve Jobs of China Medical. So I do everything in the company, all the way from strategy to direction, to board meetings, so staff meetings. Then all the board meetings, I make sure that the board of directors has an agenda, they have a proper strategy. And as you know, we're a medical company, and we are also in the business of, amongst other things, like building hospitals. So we need to make sure that everything's in order, that we have proper subcontractors and contractors, that everything is done on time, and there's a proper SOP for everything. So this SOP is extremely important. So not only must there be a step-by-step account of what is going to happen, but the steps must be completely thought through, and thought through in the sense that not just
Mr. Zhuang, sorry,
A to B.
Mr. Zhuang, Mr. Zhuang, I'm sorry to just stop you here, but you mentioned that you were involved and you are involved in everything in China Medical. Specifically, were you involved in the construction of the hospital in Beijing?
Oh, hospital in Beijing. I guess you're talking about the hospital that is the subject of this arbitration, right? You see, because my company is very big, and then we have like 100 hospitals. But if you're referring to the hospital that is subject of this arbitration, the Xi'an hospital,
Mr. Strong, can you please stop for a moment? Okay, at this juncture, I just wanted to say, in a remote hearing, when the counsel speaks over the witness, it actually becomes very obvious and stark. And because of that, there are two things that a counsel must bear in mind. One is that because of the fact that the hearing is not taking place in person, it is very difficult to use physical gestures or hand cues to stop the witness from giving a very long answer. Which means that in a situation where the counsel needs to stop the witness, the counsel may find himself or herself in a situation where he or she has to talk over a witness. And this, because it's a remote hearing, comes across as very stark and may not go down well with the tribunal members. So in a remote hearing, it may be important to actually refrain and try to refrain from speaking over the witness and speaking over opposing counsel as well as the tribunal members. The second point is, because of the fact that this is a remote hearing and not in person, and there is the lack of the physical presence of the counsel as well as the physical presence of the witness, there is a certain amount of lack of control over the witness as one would necessarily have in an in-person hearing. But that's not to say that counsel cannot continue to maintain control over the witness. I think that is something that can continue to be done, provided that counsel ensures that the questions that are put to the witness are short, direct, leading, and not, in a sense, convoluted. So if you put a very closed question to the witness, you will ensure that the witness will give a direct answer. And even if the witness decides not to give a direct answer, the tribunal members may step in and ask the witness to give a direct answer to what is a simple question. We will now simulate this part of the witness cross-examination. Mr. Zhuang, specifically, were you involved in the project planning of the hospital in Beijing?
Well, that's a very tough question. I would say both yes and no. So I'll tell you how I was involved. I was involved in the sense that I had oversight over it, and I took great care in appointing a particular project planner from a particular contractor called Zeta Corporation. And his CV is very, very good and very, very long. And I made sure to interview him both before I appointed him to make sure that he had the required credentials. And also, when the project was ongoing, I will call him at least once a week and ask him, how's the project coming along? Are there any prospective delays and this and that? So in that sense, I guess I was involved, but I was not directly involved, if you get what I mean. I wasn't on site. I wasn't wearing the yellow hat and saying to the workers, hey, what's happening? I wasn't personally involved in the supervision of workers. I wasn't personally involved in the site inspection. And all these things, I'll just leave it to the contractor and the subcon to do properly. And also, I will call the project planner, but that is basically the extent of my involvement. So I'm not sure if that is the answer you're looking for, but I guess it's both yes and no. I was involved in that sense.
Mr. Zhuang, you've given a very lengthy answer to a very simple question. Can you please pick up Agreed Bundle of Documents, Volume 2, and turn to page 506?
Give me 1 minute. Let me search for the page. 506, right?
That's correct.
Okay, Ms. Koh, I'm at page 506.
At page 506 is the project schedule for the construction of the hospital in Beijing.
Yes.
It is stated at page 507 that the Beijing hospital would be constructed and completed by October 2019. Do you see that?
Yes, yes.
And at page 510, do you see a signature on the sign-off on the project schedule?
Yes, yes.
And Mr. Zhuang, this is your signature, correct?
Yes, that's my signature.
So Mr. Zhuang, you would accept that you were involved and indeed approved the project schedule for the hospital?
Yes, yes, I signed off on it. So yeah, I must have signed off and approved on it. Yes.
Okay, this is the end of the simulation. So I think what we seek to show with this simulation is that sometimes it may be more effective not to talk over the witness, to allow the witness to continue with the explanation, and subsequently to bring the witness back to the documents which clearly speak for themselves and can be used to challenge the answers that were given by the witnesses earlier. We hope, and I certainly hope, that you guys have enjoyed this video presentation as well as the two simulations, and that you will be very much more better prepared for the remote hearing in this COVID-19 environment. Thank you very much, and thank you, Mr. Zhuang.